Hmm?
The 16-day value.
Team number? Yes. What do you have to say? Why? These are 2013 matters. No adjournments. No adjournments, sorry.
No one.
What is this matter about?
We can challenge the state government and challenge the order passed by the Assam Human Rights Commission, whereby he was life convict.
Oh, that one.
Yes.
3-4 days.
He was, remission was granted. And accordingly, the Assam Human Rights Commission has calculated the remission from the date of expiry of 20 years. Accordingly, the findings of the Assam Human Rights Commission was that there was a delay of 3 months. Accordingly, compensation of rupees 3 lakhs was imposed. Challenging that, Lordship, we have approved this honorable court. And
I had asked you something,
yes, Lordship. On that day,
taking into account that the amount of 3 lakhs have been burdened upon the state on the account of laxity on the part of the inspector Abhiman as well as the superintendent of jail, Mr. H. Sharma. So I'll provide the names of the state officials who were holding the post at that.
I got it.
Who were they?
The Lordship, prior to that, Lordship,
Yes.
if your Lordship comes to page 18 of Annexure 2, that's because your Lordship is satisfied that 3 years after the expiry of 20 years, that is not the law. But here, as per your Lordship's observation, that there is a delay of from 23rd to 28th. From 23rd, the government order for release of the state convicts. This is the fourth one, Lordship. Office of the IT prison. Then 24 is a holiday, 25 is a holiday. On 26, file processed. On 27, WT message sent. On 28, he was released. So your Lordship observed that from 23rd, as because the order was that he is to be released immediately. So your Lordship has held that from 23rd to 28, there is a delay of 7 days. My respectful submission is that Lordship 24, we can exclude 24 and 22.
Why?
As because under the General Council Act, Lordship, the audit, as because the IG prison, it's an office, Lordship, it's not a prison. It's an office, Lordship, because closed on those 2 dates. On 26th, we should have, but Lordship, I think for arguing that line, Lordship, but most probably there is a delay of 1 or 2 days. And from superintendent of, he has sent me the register. May I place this Lordship in WhatsApp, Lordship? Your Lordship, it is as a part of the record also. He received it on 28th.
What did you receive?
The message. Released on 28/3/12 on expiry of sentence, I government notification order number so dated 22/3 informed by IG prison by so which received on 28/3.
2012.
Yes, and because Lordship, if we go by the jail manual that we have annexed, I am placing it before your Lordship at page 28. release of light convict. 4.
Hmm.
The superintendent shall submit to the inspector general for every half year ending 30th of June, 31st of December following it in respect of any light convict who has completed as on 30th of June, 31st of December, or is due to complete within the next quarter, 20 years imprisonment, including any remission, and under the rules. The scripted role report as to the light convict's conduct and performance in prison and remark as to his fitness for it. The inspector general shall thereupon send his recommendations to the appropriate government who will communicate the order remitting or refusing the life sentence to the inspector general for transmission to the superintendent. So accordingly, Lordship, it was transmitted, he received it on 28, on that very day, the superintendent has released the person, the life one.
So the inspector general shall thereupon send his recommendation to the appropriate government,
Yes,
who will communicate the order remitting or refusing the life sentence to the inspector general
sir.
for transmission to the imam.
Sir.
If the life sentence is remitted, they shall release the imam on as such date as may be specified in the order.
Order.
Then here is an order which have been passed. Let us on 23rd. 23rd was the order passed.
Yes.
Okay. On 23rd, you did not get it. The inspector general got it on 24th.
Yes.
On 24th, why he was not released?
The 24th and 25th, government.
So, government holidays, nobody is released.
No,
Show
no.
me that.
No, in the jail release, but the inspector general should have to have,
So, the release order was received
You
in
must
the
have to
office
transmit
of
the
the
order to
IG
the-
prisons on 23rd itself.
yes.
Why did you wait for 24th, knowing it to be a holiday?
No, I'm talking about the superintendent.
I am not concerned. The super, here it seems that the entire blame is on the inspector general. Was there?
No, because 2 persons were there, Lordship, pursuant to your Lordship's order, 2 persons were there. But from that record, it reveals that superintendent got that order on 28, on that very day, yes, released. So reading upon that, the superintendent, the IG prison. So IG prison, Lordship,
Why he not released on that day? If it
I
is
think,
that or their
Lord-
office is going to be closed, then why didn't he release on that date?
may.
What other formalities are required after the order has been passed by the government?
But had it been, Lordship, forthwith,
No, immediate. What else? What do you mean by immediate? The immediate means on that day immediately. So on 23rd, when it was received, why it was not released on that date?
no, Lordship, the order received by the office, Lordship, thereafter it was done, and the IG prison has after.
No, he cannot. It is a question of liberty. It's a liberty. So now why?
He is not responsible.
Because here there are two things. One is a constitutional thought which has happened, for which the state has to be bound. One. And the second is as regards not only a damage which is being caused to the petitioner who have been affected, there is also a violation to the provisions. Person's rights under Article 21. You have kept him immediately thereupon. Once he has been released by the government, there is no other way.
My humble submission is that Lordship may exclude that 24 and 20.
No. Why? Why 24 and when it was received on 23rd?
Government was ready for it, yes.
Now the 3 lakhs which was there was okay. It was reasonable earlier. But now I don't think 3 lakhs is reasonable. There has to be more than that.
I humbly beg Lordship, that may not be increased.
Huh?
That's where I can make Lordship, that may not be increased.
Why? Because this is something which is very serious. A person's human rights is, we are concerned.
That That is their lordship, that's because, but, having the account lordship cannot. Yes, lordship, some. Is also seen lordship, but if you exclude that 24 or 20, that on, also on 26, he should have been, that the order should have been communicated to the superintendent. But it was sent to the ATR or there of the WT message, it was received by.
Now, let us take Article 22. A person cannot be detained. If he is detained, there are certain parameters given that if we go by the National Security Act and all, within a particular period of time, you have to do everything. So this amounts to an illegal detention, yes. It is subject to recommendations. Once it has been recommended, and there is an order being passed, thereafter keeping him for 1 day more would amount to infraction. And where is it mentioned that on Sunday a person cannot be released? And if that is not the law, then it has to be. It is a question of person's human rights. Article 20.
Superintendent has received that order on 28.
Whoever went the superintendent, then that I will leave it to be deducted from the salary by the authorities if they wish. That is different. That they let them do it if they want.
And in the rule itself also, lordship is specifically like as such day as when specified in the order. They are not specified.
Yeah.
How are you lordship?
And there was no payment. No, there was a complete stay. Interim, there is,
I have not.
interim is yours. You are asking for interim.
Yes, sir. Whether it is granted, I have not done.
Issue notice having regard to the law and parameters that shall not appear to be correct and make use of the having had regard to the submission area, impugn order is stayed. No? Okay, tell me. So the delay is only for 4 days. Not more than. No. The incident with petition have been filed by the state of Assam. Challenging the order dated 22/11/2022 passed by the Assam Human Rights Commission in AHRC case number 307/10/11-12. It appears from the records that the respondent number 1 herein was a life convict undergoing his life imprisonment in the district jail of Karimganj in connection with Sessions case number 16/1995, registered under section 302/34 of the Indian Penal Code with effect from 23/2/1998. The record further reveals that that a proposal for release of the respondent number 1 was received by the dealing assistant of the office of the Superintendent District Jail Karimganj on 2/2/2012. A WT message was sent to the jail superintendent on 3/2/2012, asking for the proper receipt of the payment of the fine by the convict, the final release proposal was submitted by the IG Prisons to the government on 10/2/2012. Proposal for final release of the respondent number 1 was submitted to the government by the Inspector General of Prisons, Assam, on 10/2/2012. Thereupon, on 23/3/2012, the government, where is that communication?
Order, Your Honor. At page 33.
Thereupon, on 22/3/2012, the Secretary to the Government of Assam, Home and Political Department, issued a notification bearing number HMB 128/2001/PT/327, wherein it was mentioned that the respondent number 1 had completed 20 years of total imprisonment, including remission earned in jail, as well as 14 years of actual imprisonment, including under trial detention period set off under section 428 of the Code of Criminal Procedure 1973. It was further mentioned that taking into account the conduct and performance of the respondent number 1 in the jail, the governor of Assam was satisfied that the respondent number 1 had become fit for release. Accordingly, by exercising the powers under section 432, read with section 433A of the Code of Criminal Procedure 1973, the governor of Assam was pleased to remit the life sentence of the respondent number 1 and to accord approval for his release with immediate effect. It is seen that the said order of the governor it is seen that the copies of the said order of the governor was marked to the Inspector General of Prisons, Assam, The superintendent, MNR Open Air Jail, Jorhat, the superintendent district jail Karimganj for information and necessary action, as well as copies were marked to the Minister of Jails, Assam, to the Private Secretary to the Minister of Jails, Assam, and the Private Secretary to the Commissioner and Secretary Home and Political Department, Dispur. It is pertinent herein to take note of that on 23/3/2012, the government order to release the respondent number 1 dated 22/3/2012 was received by the dealing assistant of the Office of the IG of Prisons. The record further reveals that on 24, 25, 26, and on 27 of March 2012, the respondent number 1 was not released, although the order of the governor was specific to be released with immediate effect. It was only on 28/3/2012 the respondent number 1 was released. It further reveals that a complaint was filed before the Assam Human Rights Commission alleging that the respondent number 1 was detained for about 1 month in excess before his final release from the jail. The Assam Human Rights Commission, by an order dated 16/2/2012, took cognizance of the said complaint and directed the IG Prisons, Assam, to look into the complaint and submit a report. Thereupon, the IG Prisons, Assam, submitted the report on 13/3/2012, stating inter alia the fact that a proposal for releasing the respondent number 1 had already been submitted to the government through the letter dated 10/2/2012, and the release would be effective immediately after the receipt of the release order from the government. The said report which was submitted by the IG Prisons was thereupon served upon the complainant, asking for his comments. On 11/4/2012, the brother of the respondent number 1 contended that the respondent number 1 was released on 28/3/2012 after unlawfully detaining him in jail for more than 1 month. The Assam Human Rights Commission thereof, by an order dated 11/7/2012, directed the IG Prisons Assam to clarify the matter of the alleged overstay of the respondent number 1 in the jail. The IG Prisons Assam submitted a clarification report on 31/7/2012. The said clarification report have been enclosed as Annexure 2 to the writ petition. From a perusal of the said clarification report dated 31/7/2012, it transpires that the Inspector General of Police, the Inspector General of Prisons, had given the following dates. Which is quoted here in below. And had given the date-wise descriptions of the activities carried out, which led to the release of the respondent number 1. The said dates, the said activities, date-wise description of the activities being relevant for the purpose of adjudication of the instant petition is reproduced hereunder. Page 18-19 of the date 202 on 2/2/2012 of right, the date 28. On the basis of the said clarification, the Inspector General of Prisons Assam requested the Assam Human Rights Commission to consider the matter on merit and to brace it and to drop the case. It further reveals that the Assam Human Rights Commission came to a finding that the government of Assam took as many as 40 days in issuing the final release order on 22/3/2012. And accordingly, the respondent number 1, who was due to be finally released from jail on expiry of his life term on 28/2/2012, was released on 28/3/2012. That is 1 month after the due date, which is a serious illegality amounting to illegal detention of the convict of the respondent number 1 in the jail for no fault of his, and can certainly be attributed to the negligence and dereliction on the in the duty on the part of the official staff concerned. The commission thereupon also observed that the illegal detention of the respondent number 1 was in flagrant violation of human rights of the respondent number 1, affecting his life, liberty, and dignity, and resulting in clear infringement of Article 21 of the Constitution, with which the Commission is seriously concerned. On the basis of the above, the Commission directed the payment of compensation of ₹3 lakhs to the petition respondent number 1, which may be realized from the concerned officials found to be involved in such act, as well as to initiate disciplinary proceedings for taking appropriate actions, respectively, against such officials of the staff whosoever as are found to be responsible for causing the belated release of the victim, that is, the life convict, that is, the respondent number 1. It was further directed that the action taken report be submitted to the Commission within 90 days of the receipt of the orders. Being aggrieved with the said order dated 22/11/2012, the state of Assam the Inspector General of Prisons, Assam, and the Superintendent of the District Jail, Karimganj, have jointly filed the instant writ petition. On 29/8/2013. It reveals from the records that this court, by an order dated 16/9/2013, issued notice and state the impugned order dated 22/11/2012. The record further reveals that this court, by an order dated 16/2/2015, issued rule, and the interim order so passed earlier was directed to continue till the disposal of the writ petition. From the records, it is also apparent that on 17/9/2014, the respondent number 1 had filed an affidavit in opposition. A book is Judgment too late. AIR 1976 SC 1552. You have a copy of it? Ratan Singh's judgment. From a perusal of the said affidavit in opposition, it reveals that the respondent number one had justified the import the impugned order
Accounting judgment also we are relying. This reflects that this overall.
Yes. What is this Ratan Singh?
That would be at least more about it. We are relying.
You see, the judgment in Ratan Singh or even Sangeet are in respect to the question pertaining to that it is not a right.
And because the Assam Human Rights Commission calculated it from 28 to 31 of replacing with them.
In the above backdrop, the question which arises for consideration is as to whether the order, impugned order dated 22/11/2012, is required to be interfered with by this court in exercise of its in exercise of its jurisdiction under Article 2 to 6 of the Constitution. Before further proceeding, before further proceeding, this court finds it relevant to take note of the relevant case laws the relevant case laws on the issue. Inasmuch as the petitioners have duly relied upon two judgments of the Supreme Court, that is, the cases of the state of Madhya Pradesh versus Ratan Singh and others, reported in AIR 1976 SC 1552, as well as the judgment of the Supreme Court in the case of Sangeet and another versus the state of Haryana, reported in 2013 2 SCC 452. In the case of Ratan Singh and another Supra, related to a case wherein one Ratan Singh, who was convicted by the Sessions Judge Bhind in the state of Madhya Pradesh under Section 302 and sentenced to life imprisonment for life, made a prayer to the government for transferring him from Gwalior jail to Amritsar, as the said Ratan Singh belonged to Punjab state. The said representation of Ratan Singh was accepted, and accordingly he was transferred to Punjab jail, where he was lodged at the central jail Amritsar. The order of transfer was passed on 15/10/1959. It was the case of Ratan Singh, the respondent, Ratan Singh, that as he had completed the period of 20 years imprisonment, including the remissions granted under the Punjab jail manual, he would be entitled to be released forthwith and he accordingly made an application for his release to the Punjab government. In fact, at the time when the Said Ratan Singh had made the application, the Said made the application come. He had already undergone imprisonment for a period of 25 years, 18 days, 19 hours, taking into account the various remissions granted to him from time to time. The government of Punjab forwarded the representation of the Said Ratan Singh to the government of Madhya Pradesh for passing an order of release. On 18/4/1971, the state of Madhya Pradesh rejected the request of the respondent for his release. Under such circumstances, the Said Ratan Singh filed a writ petition in the High Court of Punjab and Haryana on the ground that the accused had been served the sentence for more than 20 years, was entitled to be released as a matter of course under the provisions of the Punjab Jail Manual and the rules framed under the Prisons Act. The High Court, the Punjab and Haryana High Court, accepted the plea of the Said Ratan Singh and held that the Punjab state was the appropriate authority to release the Said Ratan Singh. It further appears that thereupon, in pursuance to the order passed by the Punjab and Haryana High Court, the respondent, the Said Ratan Singh, was released. It is under such circumstances the state of Madhya Pradesh had filed an appeal before the Supreme Court, contending that it is the Madhya Pradesh High Court, Madhya Pradesh government alone who has the power to remit the sentence and release the prisoner. And the Punjab and Haryana High Court was in error in holding that the Punjab government could have passed the order of release. It is under such circumstances the judgment was rendered in the case of Ratan Singh Sutra, whereby it was held that the order passed by the Punjab and Haryana High Court was erroneous, and accordingly the appeal was allowed. But as the Said Ratan Singh was already released, the order of release of the respondent of the release would stand. At paragraph number 9 of the said judgment, the Supreme Court laid down the following propositions, which for the sake of convenience is reproduced hereunder. 9, 1, 2, 3, 4. Paragraph 9 to 4. From the above propositions, it appears that a sentence of imprisonment for life does not automatically expire at the end of 20 years, including remission. As the administrative rules framed under the various jail manuals or under the Prisons Act cannot supersede the statutory provisions of the Indian Penal Code. It was observed that a sentence of imprisonment for life means a sentence for the entire life of the prisoner, unless the appropriate government chooses to exercise its discretion to remit either the whole or a part of the sentence under Section 401 of the Code of Criminal Procedure. The other propositions which have been stipulated in subparagraphs 2, 3, and 4 relates to which appropriate government can order such release. And as regards the judicial review against an order of refusal to release. Be it as it may, the said proposition makes it clear that a discretion has been conferred upon the state government, appropriate government, to remit either the whole or part of the sentence under Section 401 of the Code of Criminal Procedure. In the backdrop of the above, let this court come to the deal with the judgment of the Supreme Court in the case of Sangeet and another case of Sangeet and another Supra. তার আগতে হেতুতে লিখিলে আপনি 401 লিখিলে না লাষ্টত 401 এটো Code of Criminal Procedure যত লিখিছো it will be 1898 আগত রতন সিংহৰ কেছ ঠিক আছে The judgment in the case of Sangeet and another Supra was rendered under the extant Code of Criminal Procedure 1973. In the same judgment, the Supreme Court dealt with the procedural checks on arbitrary remissions, as well as the substantive checks on arbitrary remissions. Amongst others. In paragraph number 77, the Supreme Court observed its conclusions. Paragraph number 77.5, 77.6. And 77.7, as it relates to remission, the same paragraphs are quoted here in under. Corruption. From the above quoted portions, the Supreme Court concluded in the case of Sangeet and other supra that the grant of remission is a statutory power. And to prevent its arbitrary exercise, the legislature has to build in some procedural and substantive check in the statute. It was observed that remissions can be granted under Section 432 of the CRPC in the case of a definitive term of sentence. The power under the said section is available only for granting additional remissions, that is, for a period over and above the remissions granted or awarded to a convict under the jail manual or other statutory rules. It was further observed that if the term of the sentence is indefinite, the power under Section 432 CRPC can certainly be exercised, but not on the basis that the life imprisonment is an arbitrary or notional figure of 20 years of imprisonment. It was further observed that before exercising the power of remission under Section 432 of the CRPC, 1973, the appropriate government must obtain the opinion, bracket, with reasons, of the presiding judge of the convicting or confirming court. And remission can therefore be given only on a case-by-case basis and not in a wholesale manner. Here, people. In the backdrop of the above propositions, as settled by the Supreme Court, this court finds it relevant to take note of the relevant provisions which relates to remission, which relates to suspension, remission, and commutation of sentences. Section 432 of the Code of Criminal Procedure 1973 empowers the appropriate government with or without any condition to suspend the execution of the sentence or remit the whole or any part of the punishment to which a person have been sentenced. In section 433, the appropriate government have been empowered without the consent of the person sentenced to commute amongst others a sentence of imprisonment for life, for imprisonment for a term not exceeding 14 years, or for fine. Section 433A stipulates imposes certain restrictions on the power of remission or commutation in certain cases. Therefore, from the law laid down by the Supreme Court in the case of Ratan Singh Supra, as well as in Sangeet and others Supra, read with the provisions of section 432, 433 and 433A, it appears that the power to be exercised by the state, by the appropriate government, is a discretionary power to remit the whole or any part of the punishment to which a person has been sentenced. At this stage, this court further finds it relevant to take note of the Assam Jail Manual, more particularly chapter Roman 19, which relates to the remission system. Rule 326F defines life sentence to mean a sentence of imprisonment for life semicolon life convict means a prisoner sentenced to imprisonment for life semicolon, and imprisonment for life means imprisonment for the entire life of the prisoner, comma, unless remitted earlier by the appropriate government. Rule 571 bracket 4 relates to release of life convict. The said portion being relevant, the said subrule 4 being relevant, subrule 4 of rule 571 being relevant, the same is reproduced hereinunder to page 28 or page 29. Yellow gold. From perusal of the said above quoted rule, subrule, it would be seen that the procedure to be followed for the purpose of applying for remission have been mentioned. It stipulates that the superintendent of the concerned jail shall submit to the Inspector General of Prisons for every half year ending 30th June / 31st of December the details stipulated therein in duplicate in respect of any life convict who had completed as on 30th of June / 31st of December or is due to complete within the next quarter 20 years imprisonment, including any remission earned under the rules. The details which are required to be sent in duplicate are Roman 1, descriptive role, Roman 2, report as to the life convict's conduct and performance in prison, and Roman 3, remark as to his fitness for release. The Inspector General of Prisons, upon receipt of the said recommendation, upon receipt of the said details from the superintendent, shall thereupon send his recommendation to the appropriate government, who will communicate the order remitting or refusing the life sentence to the Inspector General for transmission to the superintendent. If the life sentence is remitted, the superintendent shall release the life convict as such date as may be specified in the orders. Therefore, from sub-rule 4 of Rule 571 of the rules for management of jails in Assam, it would also show that the appropriate government has a right to remit or even refuse the proposal for remission. In the backdrop of the above analysis, let this court therefore take into consideration the facts involved and the order, and along with the impugned order. The superintendent on 2/2/2012 submitted the proposal in terms with section Rule 571(4) to the Inspector General of Prisons, Assam. The Inspector General of Prisons, Assam, upon receipt of the said proposal, along with the fine payment receipt of the convict of the respondent number 1, submitted the proposal for final release, submitted the proposal of remission to the government on 10/2/2012. On 22/3/2012, The government passed the order. In the name of the governor, thereby granting the remission to the petitioner and further ordering that the petitioner granting remission to the respondent number one and further ordering that the respondent number one be released with immediate effect. This court at this stage finds it relevant to take note of that though the power to grant or refuse remission is an absolute discretion, is within the discretion of the government. But there is no explanation in the writ petition, as well as also in the clarification dated 31/7/2016 at 12 and closed as Annexure 2, why the state government took time from 10/2/2012 till 22/3/2012 for processing till 22/2/2003/2012. Although the state of Assam is the petitioner number one in the instant proceedings. Is there any mention? No. Okay, let me come in 5 minutes. It was expected that the state of Assam at least ought to have explained why it had taken almost 40 days for passing the said order of granting remission to the petitioner, to the respondent number one. That to when the state of Assam is the petition number one. Next. Be it as it may, there is no enforceable right of a prisoner to be released, of a prisoner who is a life convict to be released on completion of 20 years. In the instant case, the right to be released from the jail accrued upon the respondent number 1 upon passing of the order dated on the basis of the order of the governor dated 22/3/2012, wherein it was categorically mentioned that the respondent number 1 be released with immediate effect. The clarification dated 31/7/2012 of the Inspector General of Police Prisons categorically state that on 23/3/2012, the order dated 22/3/2012 was received. In the same clarifications, except stating that on account of holidays on 24th and 25th, being second Saturday and Sunday, fourth Saturday and Sunday, the order of the governor dated 23/2/2012 could not be acted upon. 22/3/2000 could not be acted upon. It was further mentioned that on 26 and 27, the file was processed, and on 28, the respondent number 1 was released. This court fails to understand as to what stopped the office of the Inspector General of Police Prisons to issue appropriate directions pursuant to receipt of the order of the governor dated 22/3/2012 on 23/3/2012, and why that too when the order of the governor dated 22/3/2012 categorically stated that the respondent number 1 should be released with immediate effect. Nothing could be shown by the learned counsel appearing on behalf of the respondents, on behalf of the petitioner, state of petitioners, that the prisoner cannot be released on a fourth Saturday or Sunday. Which there is also nothing shown as to why on 26th and 27th, why it took another 2 days thereafter, that is on 26th and 27th of March 2012, for processing the papers. In as much as a reading of sub-rule 4 of Rule 571 of the rules for management of jails in Assam do not contemplate any anything except transmission of the order of the governor by the Inspector General of Prisons to the superintendent. Today, when the matter was taken up, Mr. H. Sharma, the learned counsel, appearing on behalf of the petitioner state, submitted that the Inspector General of Prisons had sent the have submitted that the communication issued by the Inspector General of Prisons dated 27/3/2012 was received on 28/3/2012 by the Superintendent, District Jail, Karimganj. This clearly therefore shows that there was laxity on the part of the Inspector General of Prisons from 23/3/2012 to 27/3/2012. From 23/3/2012 to 28/3/2012. In as much as the respondent number 1 was only released on 28/3/2012. Next. Now coming to the order of the governor dated 22/3/2012, it categorically mandates that the respondent number 1 be released with immediate effect, meaning thereby any further detention from the date of receipt of the said order by the Inspector General of Prisons would amount to and illegal detention of the petitioner
Yes, sir.
without any authority of law. At this stage, this court finds it relevant to take note of the judgment of the Supreme Court in the case of D.K. Basu versus the state of West Bengal, reported in 1997, 1 SCC 416. It was observed by the Supreme Court in the said judgment that a claim in public law for compensation for unconstitutional deprivation of fundamental right to life and liberty, the protection of which is guaranteed under the Constitution, is a claim based on strict liability and is in addition to the claim available in private law for damages for tortious acts of the public servants. It was observed that public law proceedings serve a different purpose than the private law proceedings. Award of compensation for established infringement of the indefeasible rights guaranteed under Article 21 of the Constitution is a remedy available in public law, since the purpose of the public law is not only to civilize public power, but also to assure the citizens that they live under a legal system wherein their right and interests shall be protected and preserved. It was further observed by the Supreme Court that a grant of compensation in proceedings under Article 32 or Article 2 to 6 of the Constitution for established violation of the fundamental rights guaranteed under Article 21 is an exercise of the court under public law jurisdiction for penalizing the wrongdoer and fixing the liability for public wrong on the state which failed in the discharge of its public duty to protect the fundamental rights of the citizen. The Supreme Court further, in the said judgment, observe that for violation of the fundamental right to life or basic human right, amounts to violation of the rights guaranteed under Article 21 of the Constitution. And the state would be vicariously liable for the tort committed by its employees. Under such circumstances, in the backdrop of the above, in view of the above analysis, it is clear that though it may not be a delay, though the respondent number one may not have an enforceable right for claiming damages in the delay in processing of the remission papers by the government pursuant to the proposal submitted on 10/2/2012. But pursuant to the order dated 22/3/2012, the respondent, the petitioner number 2 and 3, could not have kept the petitioner in the jail after receiving the order of the governor on 23/3/2012.
Number 3. Go by the 571(4). He has to act upon after receipt of the communication from the IGP, not priority. That is why I'm on 54 that is why.
But both are jointly responsible.
Because if we cannot get the order, how we can act upon it? That is the first point.
This will give you a right to go to the division bench.
That is what the point of
Therefore, a constitutional tort have been committed by the respondent, by the petitioner numbers 2 and by the petitioner's hearing, for which the petitioner number 1 would be vicariously liable. Therefore, the next question which arises is whether this court should interfere with the order passed by with the impugned order passed by the learned Assam Human Rights Commission. A perusal of the writ petition and the relief sought for shows that the petitioner have sought for a writ in the nature of certiorari for the purpose of setting aside and quashing the order dated 22/12/11/2012. At this stage, this court finds it relevant to take note of the judgment of the recent judgment of the Supreme Court in the case of Central Council for Research in Ayurvedic Science and another versus Bikartan, Das and others, reported in 2023 SCC Online SC 996. In paragraph number 50, 51, and 52, the Supreme Court dealt with the principles for issuance of a writ in the nature of certiorari. It was observed, the same paragraphs being relevant is reproduced here in under 50, 51, 52. From a perusal of the said paragraphs, it reveals that there are two cardinal principles for the purpose of exercising the jurisdiction under Article 2 to 6 of the Constitution for issuance of a writ of certiorari. First, that the High Court, while exercising the jurisdiction under Article 2 to 6 of the Constitution, does not sit as an appellate authority over the authority which passed the order. The High Court does not review or reweigh the evidence upon which the determination of the inferior tribunal purports to be based. The High Court only demolishes the order which it considers to be without jurisdiction or palpably erroneous, but does not substitute its own views for those of the inferior tribunal. It was categorically observed by the Supreme Court that the writ of certiorari can be issued if an error of law is apparent on the face of the record. And a writ of certiorari, being a high prerogative writ, should not be issued on a mere asking. The second cardinal principle for issuance of a writ of certiorari is that in a given case, even if some action or order challenged in the writ petition is found to be illegal and invalid, the High Court, while exercising its extraordinary jurisdiction thereunder, can refuse to upset it with a view to doing substantial justice between the parties. It was observed that it is perfectly open for the writ court exercising these flexible powers to pass such orders as public interest dictates and equity projects. The legal formulations cannot be enforced divorced from the realities of the facts situation of the case. While administering law, it is to be tempered with equity, and if the equitable situation demands, after setting right the legal formulations, not to take it to the logical end. It was observed that the High Court would be failing in its duty if it does not notice equitable considerations and mold the final order in exercise of its extraordinary jurisdiction. And any other approach would render the High Court a normal court of appeal, which it is not. In the backdrop of the above legal formulations, as set out by the Supreme Court for the exercise of a writ in the nature of certiorari, the question therefore arises as to whether any interference is required to the impugned order dated 22/12/2012, passed by the learned Assam Human Rights Commission. On the ground, merely on the ground, that the Assam Human Rights Commission had granted a compensation of rupees 3 lakhs on account of, by taking into account that there was a delay of 40 days from the date of the proposal for releasing the respondent number 1. As already observed above, there can be no, as already observed above, the right to be released had accrued upon the respondent number 1 on 22/3/2012. Any delay prior thereto by the government though ought to have been explained in the writ petition, as the state was the petitioner. But for that purpose, it cannot be said that the petitioner's right under Article 21 of the Constitution have been violated. However, after 23/3/2012, the reasons to assign are not legally tenable. And this clearly violates the mandate of Article 21 of the Constitution. Of the respondent number 1. The amount of 3 lakhs which was awarded as compensation, though was based upon a delay of 40 days. But taking into account under such circumstances, in order to do substantial justice between the parties, this court is not inclined to interfere with the order, impugn order dated 22/11/2022 passed by the learned Assam Human Rights Commission. The petitioner's hearing are directed. The petitioner number 1 hearing is directed to disburse the amount of rupees 3 lakhs within 15 days, within 1 month, within 30 days from the date a certified copy of the order is served upon the respondent number 1, upon the Commissioner and Secretary to the Government of Assam Home and Political Department. The petitioner number 1 shall also make necessary inquiries as regards the persons who were responsible, for which there has been an infraction to the rights under Article 21 of the Constitution of the petitioner. It shall be within the liberty of the petitioner number 1 to take appropriate actions upon such persons found guilty on such inquiry being conducted, to recover the amount which the petitioner number 1 is being directed to make payment. It is further mentioned herein that if the amount which has been directed to be paid, if not paid within the period of 30 days from the date of submission of the certified copy, the petitioner not only shall be entitled to resort to such other remedies, the respondent number 1 shall not only be entitled to resort to such remedies for violation of the directions passed by this court, but shall also be entitled to interest at a rate of 6% from the date of the impugned order.
Guidance to all these markets and the for guidance for future guidance they don't hire a child. For future guidance,
I think the Human Rights Commission is still dealing with the matter. It was only stayed, so it was not that. It was not finally disposed of. The Assam Human Rights Commission shall also be at liberty to further proceed with the said proceedings. As per law. Twenty-one 9. You filed it. 2522. 253. Hello. Disposed. The payment, where is that affidavit, sir? You have a copy? You have filed affidavits?
if the case of the environment is by the government of the financial aid, the outstanding case for the retirement to the employees and the
Yes, what are you saying that there is no exemption? In your affidavit? Ah. No, 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 no. You are saying, you see, the GST issued by the state. The GST issued by the central. They have granted exemption as regards your yes, payment of agricultural. Yes. Isn't, where is that notification? No, where is that notification? Hmm? 127. Yes, in exercise of the powers under section 1, the central government, on being satisfied it is necessary to do so, the council hereby exempts the interstate supply of services of description in column 3 of the table below from so much of the central tax payable thereon under subsection 1 of section 9 as is in excess of the said calculated at the rate as specified in the corresponding one, unless specified subject to the conditions. We are concerned with which one? 133. What 133? 1? Serial number? Services provided by goods by way of transport in goods, carriage of agricultural products, goods very much. No, 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 no. Huh? Which affidavit? New one. The new one. Yes, got it, got it. Where? Page? Ah.
Case 67. Serial number 54.
54.
54, I think 9986. Service relating to cultivation of plants and rearing of all type form of animals.
This is for services relating to cultivation of plants and rearing of all so and so, so and so, so and so, so and so. Agricultural operation. Services by any agricultural marketing board or services provided by a commission agent for sale or purchase of agricultural produce. So this is being exempted. Now there is a one, this is the state one.
This is the center.
Where's the state one? Page 84. 94. Services relating to cultivation. Services by any agricultural marketing committee or board or services provided by a commission agent for sale or purchase of agriculture. So this is exempted. Okay. Now, what is your power? Where is it?
Case 54.
Page 54.
Yes.
Yes.
So issued by the
With reference to the government's notification issued by the Finance Taxation Department, you are directed to withdraw the check gates under the establishment of Assam with effect from the midnight of 31st of July 2017. Normal realization of cess under so and so on the specified products from the market area will continue. So this is being given by the additional secretary to the government of Assam Agricultural Department. Okay. Now, this power, the power for you to collect cess is under what power?
Section 21, Assam Agriculture Police Packet Act.
Let us see, what does it say? Yes,
Section 21,
power. Every marketing committee shall levy and collect the cess on the agricultural produce bought or sold in the market area at a rate not exceeding 2 paisa for every 100 rupees for which a specified agricultural produce is bought or sold, whether for cash or for deferred payment. So this power is from where? Where do you get this power from? This power, the act gives a power. This act has to be made by the state. Okay. The state makes this act under what power? Is it under entry 52? Where? What is the power the state is exercising? Some constitution. What is that power? Hmm? What is your power to levy? Power is there under 21, but from where does it come from? Entry under what? Hmm? Is the state government not a party? State of Assam is not a party. Hmm? State of Assam is not represented. Ah. They don't want to represent them. Huh?
Yes, sir.
Yes, therefore, that power is not there. You see, the power was under 52. Entry 52. Entry 52 was removed. That is why I put a constitution from the house. Purana Constitution. Before 2016. You see, your power to collect this levy is under entry 52. This power is no longer there. You see, do you have a constitution? Or have you come without a constitution? And I'm making arguments like it. Yes. See, state list. Because your power, what you are doing is, if anybody brings their goods from outside to India, to the state, and the entire state has been made a market and brought and has been mentioned to be a local area. And as such, you have a power to collect the tax. Okay. That power was under entry 52. That power is no longer there. And if that power is not there, where is the question? Therefore, they have the exemptions. And you want that the additional Secretary of Agriculture says that they can collect? Yes? What is your basis? Tell me. You are the agriculture. Tell me what is your basis? Because you take that money if it is brought within the state. Or do you sell it, collect it from within the state? Huh?
The process of sale of assets, the agreement of sale of assets, has produced a delivered in the same area, the purchaser or to stop other person of the if the delivered
Sale
in
of
the market
purchase
area.
of agreement of sale of purchase delivered to the state of purchaser or to some other person. What is this notified market area? The entire state is a notified. So under such circumstances, if any goods is brought from outside, these are all goods brought from outside. And now if you say that if it is brought, you want to impose the tax.
Deliver also, the delivery took place in the market area.
Understood. But this power is on under entry 52. And that is not there. That is why everybody says all these things. And the best part is the agriculture, what additional secretary. He says he can collect. See, it was entry 52. Earlier you see this. See entry 52 of the state list. This is the power by which you were collecting. Isn't it? Now this power has been taken away. See, is it there? Now, no. After the 101 amendment, that power has been removed. And therefore, this power is no longer there under 21. If that power is not there, how do you collect?
Depending on the purpose of this.
Huh?
Depending on the purpose of this notice.
Which notice?
Notice of the additional secretary.
My goodness.
And we already stopped the collection of this from 12/6/2020.
That I understand, that you rightfully done, but for prior to that, you have done all these things, you have collected so much. So you are in a very bad position now,
Yeah. This for last 10 months.
and the government is not giving.
I'm still in that. So, yeah, I could not take a-
Yes, madam, what do you have to say? Huh? Nothing? Good. Okay. These are disposed of. I would not direct you to refund it, but there shall be no further, you cannot collect it. The refund would not be there, taking into account this affidavit as well as the judgment of the Supreme Court in the case of, I think, Dr. Phillips. What was the case of luxury tax? That is not there. Luxury tax, what is the name of the judgment? Godfrey Phillips? RC, what is that? Because as soon as one was the whole hundred. Hey, come, we don't handle it. Yes, which one? State of? No, no, that is different. There's one judgment of state of, yeah, no, Godfrey Phillips. That is a case where luxury tax was imposed. Anyways, that I will take care of it, don't worry. Okay. Dispose it. I'll pass the order. I won't spoil any further time. Coming every day out here may have made the file that. Taking it already. Dispose it. এই দুইখন দিব হা কনস্টিটিউশন এইখন এইখন হল সেই ফার্স্ট আইটেম এইখন ভৰাই দিব
Number 16.
What? This is the RTI one? Where is Mr. Talukdar? Oh, that day I've asked you to file an affidavit in this matter. What happened? You have brought in some things.
Yes. Covered an area which.
There is no available record with the bank regarding the amount of shares subscribed by the government of Assam towards the paid-up capital of the bank at the time of establishment. However, at present, as per the annual reports, the total paid-up share capital of the bank was ₹1, of which the state share was ₹1, which is around 7 of the total paid-up capital. As on hand, the total paid-up share capital of the bank is ₹1. Now, how is the government infusing the equity?
And copy of the bylaws. Bylaws itself, it's it. And in extent of the capital of the government, it's limited to 25%. Maximum extent, as per bylaw number 37.
Which is the other judgment he is referring to? Authorized share capital of the bank shall be 50 crores, made up of 100,000 shares, subject to the state government subscription to the unit of bank shall not be allowed. So when, how, no, there is, as regards the establishment, you have not stated anything.
Establishment is not at the record. Establishment is not at the record. I asked him to check.
Huh.
It's not at the record. At the time of establishment, what was the exact? If there was. But presidential lordship cannot exist.
Which are the two judgments? One,
I was referring to Kalapam.
where is that? Give them the citation, they will get it out. The two judgments. You have extra copies of both?
I have only for Kalapam.
Why? You are not interested in the law being laid down correctly?
The other one I have a soft.
Ask them to get it.
Yes.
Yes, you come by reaction authority. It will have a judgment. Take it.
2019. 180. 2019. 180. 185. Supreme Court judge. This is the judgment of the constitutional bench.
Oh, that one, that is not required. That is besides the point.
They did discuss a little bit about what will constitute by the line of
would it have anything of importance?
because it is not relied upon the college at all.
Which one?
The constitutional judgment, so only on her.
What was stated there in Kalapam,
Yes.
constitutional provisions and conventions, body owned by the appropriate government. Every public authority is also obliged to maintain all the records. What is the finding? Body controlled by the appropriate government.
Kalapam is a paragraph number 48.
Non-government, merely providing subsidies, grants, exemption, privileges, etc. as such cannot be found to be providing funding to. Merely providing subsidies, grants, exemption, privileges, etc. as such cannot be said to be providing funding in a substantial extent unless the record showed that the funding was so substantial to the body which practically runs by such funding, but for such funding it would struggle to exist. May also float many schemes generally for the betterment of the welfare of the cooperative society, like the deposits. These are here. You don't fall under ABCD. There is no quarrel. But whether you fall under 1 and 2, body owned, controlled, or substantially financed. Now, you see, your bylaw number 37 stipulates that the infusion of the equity by the state would be around 25%.
Ceiling of it.
Why?
Because under the Cooperative Societies Act, section 137, is the mandate that share capital of the state government, the cooperative society cannot accept. Perhaps
No. Why do you need that 25%?
that 25%. Now it's not 25%, now it's around 30%.
Now,
Now it's around 17.9%.
no, it's okay. Why do you need that? You read 37?
I don't know.
Yes. Isn't it for meeting the Banking Regulation Act?
In case we cannot meet it,
Then it can be increased beyond 25. But why do you need that 25%? There has to be some reason behind.
because the bank was established here.
Ah,
Authority is, it was the first such bank of its nature in Assam.
hmm.
Then it's stated in your lordship was to encourage the cooperative movement in Assam. Even now, your lordship, its primary borrowers are cooperative society, other cooperatives. It's our goals and perhaps it is because of that, your lordship, that the state government must have contributed initially also, there must have been some contribution also. And that brings the cooperative movement in the state country.
Now, does it have anything to do with the Banking Regulation Act? For running a bank? If that is so, then it has a different connotation.
If the law demands that.
Ah, there again the problem arises. Even if you read 48,
48 of.
Kalapon,
Yes.
if that is the required,
I am not.
because there, one thing what you can get in 37 is, normally it cannot be more than 25, but it can be increased for meeting the BR Act.
Yes.
So does the BR Act have any relevance to this?
Section 11 of the Banking Regulation Act, your lordship,
Hmm,
based on the requirement that it has the minimum paid up capital.
hmm.
And 11(1) says, which is the section under reference here. Notwithstanding anything contained in section 149 of the Companies Act, no banking company in existence on the commencement of this act shall, after the expiry of 2 years from such commencement or of such further period not exceed 1 year as the Reserve Bank, having regard to the interest on interest of the depositors of the company against the law, carry on business, and no other company shall, no other banking company shall after the commencement of this act commence or carry on business unless it complies with certain of the requirements of this section and are applicable to it. This section lays down certain requirements for the of capital also over.
Well, look, take it about 2, have a look at it. Because this is another aspect, whether on the basis, like in many places, like you have a land being given for the purpose of starting a something. And as per the new judgment, if that land becomes the main vital thing, then obviously it would be a public authority. Now, without the state government's contribution, can it run? Otherwise, why was it necessary for allowing 25% of
The
the?
state government can also nominate one member.
Hmm.
That is also there.
So there it has to be construed in that manner then.
I'll.
Yes. Sir. And where is Mr. Talukdar? You are who?
That's one of the five.
Oh, you still want the information? Huh?
Also, I'm the allowed to take a copy of this. I have copied it.
Yes. Where is he? The respondent number 5? He was here? Yes, tell me.
But the banking regulation act for banks which are banking companies which are registered in India, declare their case of within 3 months. If there is a requirement to have a for a fees of a maximum of 10 lakh. Without that, you cannot engage in that. And the reference to do the final revision is to that. But if it comes to that, if the 10 lakh is reached, then the state government may get set up.
So the infusion of the share capital money was put by the state when?
Project in 1948, I found the list of promoters who were present in Dr.
Right.
So in fact, next to this bylaw, these were the promoters present in the first meeting in 1948. That's the document.
No, this is okay, but without the share capital of the state. Yes, Mr. Counsel, you are a counsel or the petitioner in person? You are a counsel or the petitioner in person? Or the respondent in person? Yes.
I submission is that because of the now it's very minimal. The capital that is being used by the government. Presently, the situation is that definitely we can do without that. They have that capital very minimal. But the rules as they exist a lot, they do have a provision that if situation comes to such a situation arises where the bank cannot meet the requirements of level one of the bank regulation act.
No, now let's come to paragraph 26 of the second DAV.
Yes.
In our view, substantial means a large portion. It does not necessarily have to mean a major portion or more than 50%. No hard and fast rule can be laid down in this regard. Substantial financing can be both direct or indirect. To give an example, if the land in the city is given free of cost or on heavy discount to the hospitals, educational institution, or such other body, this in itself would be a substantial financing. The very establishment of an institution, if it is dependent on the largesse of the state in getting the land at a cheap price, would mean that it is substantially financed. Merely because financial contribution of the state comes down during the actual funding will not by itself mean that the indirect finance given is not to be taken into consideration. The value of the land will have to be evaluated not on the date of allotment, but even on the date when the question arises as to whether the state body or NGO is substantially financed. Whether an NGO or a body is substantially financed by the government is a question of fact which has to be determined on the facts of each case. There may be cases where the finance is more than 50%, but still may not be called substantially financed. Supposing a small NGO, which has a total capital of 10,000, gets 5,000 as a grant from the government. Though this grant may be 50%, it cannot be termed to be substantial contribution. If a body or an NGO gets hundreds of crores of rupees as grant, but the amount is less than 50%, the same can still be termed to be substantially financed. Another aspect of for determining the substantially finance is whether the body, authority, or NGO can carry on its activities effectively without getting finance from the government. If it is functioning is independent on the finance of the government, then there can be no manner of doubt that it has been termed as substantially financed. While interpreting the provisions of the Act and while deciding what is substantially financed, one has to keep in mind the provisions of the Act. This Act was enacted with the purpose of bringing transparency in public dealing, probability in public life. If the NGO or other bodies get substantial finance from the government, we find no reason why a citizen cannot ask for information to find out whether his or her money, which have been given to the NGO or any other body, is being used for the requisite purpose of God. So, whether the input of the capital was required for starting the bank, that's the only question. Without that, can you survive? Or could you have started your business?
48 is the list of promoters that we see.
There you don't have anything on.
That is what I. So this is yes or no, or perhaps. This is, if I ask him, what records do you have of 1948, what is the company? What I clear.
What do you have to say? Have you seen the affidavit?
One aspect of it, perhaps one of the people might be related from that you last time. 1989, one GLR 424. There, this doesn't has been healthy now. There,
19?
89, one GLR 424.
Where is it? Oh, no, I don't have it. 1989, one jeweler. No, these printouts, they remove it. Like of judgment. Give me the name, I'll take it out. In my, just 1 minute.
1989, one GLR 420.
What is the name?
Surendra Nath Kolita.
Which one?
Maintenance one JLR,
424.
level would be ready.
There are?
Level.
Yes.
When it does from the record of this 11th Act, which was acquisition and bylaws staff to the above. It will be 486. You can hold that one. State government is key funding source of our resources to that. Composition of the transfer is what is the bank to appointed by the state government. Important rules and regulations for management of the bank and also regulations for commissions of the members of the staff for the state. The bank has to comply with the governance important matters. Chief executive of the bank is the bank sector appointed by the state. State government has the power to constitute the board of the directors of the bank. This is in reference to originally office legislation. Thus, there is existence of different basic state control over the respondent bank. We have also noted that the respondent bank has subsidies on this across the government. Also, undertake some activity on discussion with the government, including part of the government activities of the financing of cooperative services and cooperative banks, sending cash relief for making available loans for agriculture. Applying the test and limited across the whole
We are concerned with this bank. This is the bank. So if this is the finding which has been arrived at, then don't you think that it would also come within the ambit of public authority having substantial control?
Why I was trying to distinguish it this difference. Firstly, the test to be a test and article 12. It's much more.
No, there's no quarrel.
Yes,
An authority may not be a state,
yes,
or maybe a state, but would not be a public authority.
yes.
There's no quarrel with that proposition. But the fact that the 6 things which have been mentioned in paragraph number 11,
Yes.
wouldn't that come within the ambit of the DAV college?
These 6 things are also reference definitely 1949 Act. For example, the power to visit the board of directors, the power to appoint the managing director, power to improve the bylaws. Those are not present in the bylaws first. Those are the differences which the legislature got with the provision of the Cooperative Expense Act. And on that basis, the division mentioned that there is different provisions for the purpose of becoming an instrument of this. Even now, you're looking, for example, if somebody wants to chat service matters, regarding service conditions for any employer of the bank, they come directly to the. That's good.
When it comes to paragraph 10,
Yes.
when it comes to paragraph 9, at the time of hearing the annual report of the banks for the years 1984-86 have been made available. Substantial investments by the state towards paid up capital of the bank. For example, in the year 85, out of the total paid up share capital of rupees 1 crore 72 lakhs, the state's contribution was 1 crore 11 lakhs. So it was that much.
That much of that.
So now it may have come down. But at that point, that is why I was asking whether for that license or whatever it may be, whether it is required. That means if the paid up capital means that was done in view of such a regular bylaw 37.
No, this bylaw is for the engineering 2007 after this 2008 act came into force.
Okay.
Now there is a mandate that it cannot be more than that. So I asked it not have the old bylaw. Perhaps that requirement was not there because this is just 2 hours.
In the year 1984, at the instance of the register, allotment of shares to individuals was kept in abeyance. State government extended to the bank an unconditional guarantee to replenish the bank the uncovered portion of the overdues and interest due, thereunder due by the old service cooperative society and large size multi-service. State government also agreed to replenish the bank in regard to shortfall in the recovery of overdues as detailed by so and so. Substantial amount of loan was given by the bank to panchayats and agriculturists. Cash credit accommodation was also extended by the bank to the wholesale consumers so and so for essential commodities including so and so. Now the composition is different from what it was earlier. Because you see, if we see here, the composition out here, the appointment, how it has to be done. Now here the chairman has to be appointed by the board of directors.
Now this
So these came when? 2009. Hmm? 2014. So therefore, this came only in 2014. Prior to that, at the time when the petition was filed, that means it was a public authority.
Thank you, Lordship. At that stage, the State Information Commission, especially two other cooperative banks, has passed orders saying that these banks are not cooperative.
But you see, the law, when it is declared by the Supreme Court, it goes back from the date of its interpretation.
Yes.
So under such circumstances, as of 2011, when the writ petition was filed, it was a public authority. There was no quarrel because of the judgment of the division bench. Because at that point of time, we are deciding a dispute at that point of time.
Yes, if it is confined to that period, then perhaps this judgment will.
Because as of now, the state has no control.
As of now, it's very limited.
Everything has been controlled. At best, a control may be there of the RBI along with NABARD. Because the criteria for appointment of a managing director and all these things would be fixed by NABARD or the RBI. So it has nothing to do with the state government any further. And the state government, only a corporation department, one person will be appointed as a member, nothing more than that. Whereas in the earlier judgment, it was different. So as per these bylaws, even as of now, one can also have a relook as to whether you are a state.
Perhaps. Yes.
Only in that way, because the basis on which it was made a state is no longer there. Yes, Mr. Talukdar.
Because this factor I have gone for. That is.
Yes, the respondent in person. Tell me. Now with a bend. Come here. What is your case? They say that they are not a public authority. What do you have to say? Huh?
Number 5 has already died.
Was that?
They have already expired.
So what to do then? Should I decide this or not?
Mission of our is. We have announced that we have been doing. Kindly let us know whether we are a public authority. Take a decision on that. Without deciding that, on an appeal made by the respondent, they pass an order to the client saying, can be provided. So now the Information Commission has all the powers of a civil court. The State Information Commission has been granted with the powers of the civil court. To call for the records.
No, the question now of remitting the matter down there does not arise. The reason why, because the person is dead.
Yes, that will. Yes.
So if the person is dead, then the question doesn't arise for remitting, because who is going to pursue the area? Response number 5 is there. Now the question therefore arises that should this court decide the aspect of you being a public authority or not in the present facts? Because what was done in DAV, it remitted the matter back to the High Court to look into on the basis of existence of those facts. Now, where does this High Court do, or what does the High Court do here? Remit it to whom? Can I remit it to there where the response number 5 is not ordered? Obviously, the question doesn't arise. Then it will be only a stalemate. Wouldn't that be issuance of a writ or infructuous writ? And why should this court decide this aspect of public authority in this question? I think I close it by keeping the question open. I think that when we have a proper case, then we will take it up. It makes no sense issuance of a or public authority for this. Some other better case, and you may also like to bring in better facts than what it is.
Perhaps.
Hmm?
Perhaps undertake an exercise in order to gather all the.
I think that is in some other cases. Yes, your name? So and so, the learned counsel appearing on behalf of the respondent number 5. Learned counsel had submitted that the respondent number 5 had already expired. Taking into account the issue involved in the instant petition, which pertains to whether the respondent number 5 would be entitled to the information which was directed by the State Commission, State Information Commission upon the petitioner. And there is no one now to be provided with the information. Nothing survives in the instant petition. The question as to, be that as it may, the question is to whether the petitioner would be a public authority within the meaning of the Right to Information Act 2005 is left open, which would be decided. It is left open to be decided in any other litigation. Is left open. This court further. We have that page. Left open or agote likhe Further to that, as the respondent number 5 had already expired, the directions given in the order dated 23/12/2010 had become redundant. Consequently, the initiation of the penalty proceedings by the communication dated 17/1/2011 by the Secretary and Register, Assam Information Commission, have also become redundant. Under such circumstances, the instant repetition stands disposed. The question as to whether the petition would be a public authority within the meaning of Section 2H of the Right to Information Act 2005 is kept open, which would be decided to be decided in a future litigation.
Supplemental is around 27 for this.
Yes, you file a PB.
Section of the level how does it what's around letting the related to the election.
No, you file an affidavit. When? List the matter again on 10th of October 2023, taking into account that the affidavit so directed by this court to be filed by the orders dated 10/8/2023 and 31/8/2023 have not yet been filed by the Joint Commissioner of CGST. The affidavit be filed by 9th of October, 6th, 3 days now, by 6th of October 2023, list accordingly.
So 17 to 19 for Jerry.
Yes, you got the records? Where is this order of 21/9/2012? Yes. What is why this order has been challenged? Hmm. Page,
Because the flats were not allotted to the traditional losses, which was subsequently cancelled. Without reading the allotment.
without hearing the LOT. It was cancelled.
Then most of them accepted
These are what houses are these?
Generally, when constructed, it's fund provided by the
Yes, last time, Mr. Bora, you were saying something.
after that. Was getting that thing. Potentially were not happy. Giving of all this person, they have to gain person.
Better. That is it.
There are two,
Only ground is not hearing.
no, getting apart from that, suppose the parents, father and mother are one. They are having two children, those are adults, they are also implied of this. So they constitute a family law, separate. If two sons are working or two daughters are working, daughters are married, they will constitute a separate family law. But in the Kumara, there's no, the father is already there, the mother is having adopted one place. So it can be disposed of by giving the direction to constitute family wise.
Huh?
Consider family wise.
No. Here we are concerned that there was some allotment made in your favor, in whoever's favor. And those allotments have been cancelled without giving you a notice. That's all.
Yeah.
What else do I have to say? So that is it. Have a look at it. These are all these repetitions have been, you have challenged these only on the ground of violation of natural justice. And he has duly admitted it, that he will give a fair hearing. And these orders are set aside.
Already more than 10 years has gone. Which will be the 2030.
Mr. Roy being there, 10 years is, what is 10 years? Isn't it, Mr. Dadu?
For the little kind of.
For Mr. Roy, 10 years is just the other day. Him 10 years is the other day. Mr. Dasgupta, you are appearing in some matters?
Yes.
How many petitioners you are having? There are 33 families in all. No, in this petition, there are 29 persons. Huh? No, the first petition, it is 30 petitioners. And second, and third,
My case is concerned, my allotment was not cancelled.
then what happened?
Because position was not cancelled. Because of the pendency of other cases. Because of the pendency of these cases of that.
Okay, yours is there. And the second petition is yours? Whose? First one is yours. You are there in WPC number 1882, 1822. Who is there in the 1265? Police Bhagat. Police Bhagat is yours. Huh? Okay, who is appearing for? And their case is also cancellation.
Allotment was there. 55.
Cancellation order passed by and direct there to give possession of dwelling houses. So it is the same like him. Some lawyer was there. But anyways, Mr. Espiro is going to do the pro bono work here. And the other is yours. Your allotment has not been cancelled,
I had deposited my allotment.
but you have not been handed over the possession. Then what is the hearing required for him?
And they have not filed a affidavit.
Huh?
There's a line vacant there, we may not.
Why the respondents have not handed over the allotted area A7 and B5 to the petitioners? Why there are two? There are two petitioners in your case.
Two allotments were available there.
And this is kept empty only because of this litigation. Means not given to him only because of this litigation. So, but you have no problem with his allotment.
Taken because of the dedicated and active that the penalty of fine for the higher regime. About their, and I think it will take a moment here. Of some of this, in terms of their employee allotment.
It's okay, whatever you do, do. But the thing is out here, you have not given him only because of this litigation, the allotment. Otherwise, you have nothing against these allotments. Lahok. The three writ petitions are taken up for disposal by this common judgment in order. You are all working as under the GMC, all of you.
Some persons are working, some are not. So all are not.
Why have you given allotment to them under this scheme? The petitioners in the three writ petitions are all scheduled caste. Belong to the scheduled caste. Just let me look at yours. Is Police Bhagat is not yours. Police Bhagat is not yours. Whether he is a scheduled caste, let me see. Otherwise, tomorrow you may say that High Court has given scheduled caste status now. Huh?
Not very pertinent, whether
Here also he is there. You are there. You are both are scheduled caste. The petitioners herein, in all the three writ petitions, claims that they belong to the scheduled caste and are working as drain mazdoor, PWD mazdoor, handcart mazdoor, road sweeper, etc. They are all residing at Potasil GMC New Horizon Colony at Potasil, Guwahati. All of them, yours also. In the case of the writ petitioners, in WPC number 1822/2013, the petitioner number 3, 6, 9, 11, 12, 23 are fourth grade employees of the GMC, are grade 4 employees of the GMC. And the petitioner numbers 5, 7, 10, and 30 are daily wage workers under the GMC. The other petitioners, except petitioner number 15, whose mother is also a grade 4 employee of the GMC, are doing the works of sweepers, scavenging, etc. in the Guwahati city of their own and earning their livelihood. In the case of the petitioners in WPC number 3185/2019, the petitioner number 1 is an employee of the Guwahati High Court serving as Safai Karmachari. And the petitioner number 2 is an employee of the Guwahati Medical College and also serving as Safai Karmachari. In the case of the petitioner in WPC number 1265/2015, the petitioner is a grade 4 employee of the GMC and working as a Mali in the Guwahati city. The said petitioner had retired in the year 2002. It is the case of the petitioners that as per 2001 population census, 285.35 million people residing in urban areas, which constitutes 27.8% of the total population. And post-independence era, while the population of India had grown 3 times, the urban population have grown 5 times, and the rising urban population had given rise in the number of urban poor. It is under such circumstances, a project in the name and style of, inverted comma, Jawaharlal Nehru National Urban Renewal Mission, bracket, JNNURM, bracket close, was initiated to cope up with the massive problems that have emerged as a result of rapid urban growth for the purpose of providing basic service to urban poor. It is the case of the petitioners that the respondents, in pursuant to the aforementioned mission, had undertaken to provide suitable accommodations of the quarters to the residents of the Potasin GMC New Horizon Colony, and for that purpose had conducted a verification After verification, the respondent asked the residents, including the petitioners, to vacate their earlier houses, public quarters situated at Horizon Colony, with a view to providing them suitable and improved housing as per the said mission, that is, projects on basic service to urban poor, and issued notices. The petitioners thereupon agreed to vacate the earlier quarters as asked for by the respondents. and thereupon also had vacated their earlier quarters. It is the further case of the petitioner that the respondents had taken earlier house for the purpose of proof for providing them new quarters as per the aforesaid mission. Further to that, it has been stated that the respondents had divided the entire Patasil GMC New Harijan colony into 3 zones, that is Zone A, Zone B, and Zone C. The petitioners claimed that they were in Zone A and Zone B, and the respondents had taken up the project for construction of the new quarters in Zone A. It has been also mentioned that as per the scheme, the respondents had constructed ground plus 3-storied RCC buildings, that is type A and type B buildings, having 16 quarters in type A buildings and 32 quarters in type B buildings. And in total, the respondents had constructed 6 type A buildings and 8 type B buildings. On the basis of the same, it was stated that there are 352 quarters in Zone A for the purpose of allotment to persons who were living in their earlier quarters and whose earlier quarters were demolished by the respondents. It has been further mentioned that the respondents had issued a building-wise allotment of the housing unit in Patasil Zone A under BSUP to 352 persons, in which the names of the petitioner number 1 to 24 were appearing, to whom the newly built quarters were to be allotted to the petitioners. 1 to 24 of WPC number 1822/2013. It was mentioned that the respondents had issued the allotment order for 269 persons, and they were allotted with newly built quarters by the respondents, and thereafter 83 numbers of quarters remained to be allotted. Subsequent thereto, the respondents had constituted a beneficiary selection and verification committee by an order dated 15/3/2012 to streamline the beneficiary selection for the Patasil BSUP project. In the remaining 83 numbers of quarters, The respondent number 5 by an order dated 21/9/2012 had notified 26 numbers of beneficiaries for final allotment. 23 numbers of beneficiaries were kept under wait list, and a claim of 28 numbers of beneficiaries were rejected. The names of the petitioners 1 to 9 belong to the aforesaid rejected list prepared by the respondents. Subsequent thereto, out of the 83 numbers of quarters, the respondent number 5 had allotted 49 numbers of quarters to persons whose names were appearing in the aforesaid 352 numbers of building-wise allotment list. And the petitioners had come to learn from reliable sources that out of the said 34 numbers of vacant quarters, the respondents have initiated the process of allotting further 4 numbers of quarters, and as such, there are 30 numbers of quarters vacant for allotment. Subsequent thereto, the respondent number 5, by different allotment certificates, allotted the petitioner number 1 to 24 different quarters respectively, in which it was clearly mentioned that the type of the building, the unit number, and the floor number allotted to the said petitions, but did not give the possession of the quarters allotted to them by the respondents on different pretexts. It was further mentioned in the petition that the respondents have also issued allotment orders, brackets subject to verification, bracket close, oblique notice, dated 10/2/2010, 5/3/2010 to the petitioner numbers 25 to 30 of WPC number 1822/2013, by which the additional commissioner GMC had stated that the petitioners would be considered for allotment of the housing unit at Potasil Horizon Colony under BSUP project, phase 1 project, as per biometric survey, and directed the said petitioners to vacate the quarters occupied by the said petitioners in Zone B of the said colony and to shift the temporary sheds constructed at Adabari. Mr. Roy, only 1 to 9 has been rejected. Isn't it, Mr. Bora? As per him, what petition has been filed, the petition is so much jumbled up.
One of mine. Limited down. 1 to 24 were allotted, and then
1 to 9 has been rejected.
Rejected circuit earlier, they were allowed.
Understood. 1 to 24 were allotted, then 1 to 9 were rejected. So this rejection is only as regards 1 to 9.
1 to 9.
Why the others?
Other plots,
Others are waitlisted,
not 10 to 10, from 10 to lot
10 to 25,
10 to
24.
24.
They are waitlisted.
And again, 25 to 30,
They were never allotted.
their cases were not considered.
They were never allotted. So under such circumstances, why have you made the mention that they were done without following the natural justice? Where is the natural justice
They
element?
had applied, they had reduced the amount of
Who?
25.
Where is it? That is the problem. Why you are filing different type of, all are having different idea. 1 to 9 has a different right compared to 10 to 10 to year. Understood. 1 to 9 is a different case category. 1 to 9 would not fall under 10 to 24. 25 to 30 is absolutely on a different pedestal.
Different level, but
Yeah.
only the ones that they were not. No.
Who? What is there to hear when they are put under waitlisting?
But listing is differently, this is lotted to 25 to 30, they were allotted.
Where? They were never allotted.
They were allotted.
Show me. Annexure 28. You will be considered for allotment. You see, here is to be considered for allotment. Everybody has a different case.
They were allotted.
Where? Kindly see page 93.
That is to be considered for reference of the money, environmental service. Therefore, timely completion of the earlier they were provided water. They were provided the water.
Where?
Dividing of the the scheme was like up.
So their case is again different. Why are you equating everybody?
But everybody was not, no notices were issued.
Why the question of notice to these people? Where is the cancellation of any of the allotments of 10 to 32 and 10 to 24? No. They are only kept under the wait list. They will be issued it.
Adoption by the order was passed by the election commission.
So,
Page 90. And nothing is need to consider when they were earlier provided the water in the following. As per the scheme of the, and as per the other letter, the precedent was given that the persons who are located for the accommodation. On the absolute law, there was a promise to provide the water. That's why we have deputies and secretaries. That's what we have been on the cap.
I'm not on that aspect. I'm on the aspect that why have you filed why don't you file anything? Tomorrow bring a question of the suit here also. There might be some cases of JJRUM out there in Andhra Pradesh also. Bring those also here. देखो खाओ itu bantu ki hai police yes Mr. Bora, what about this police Bhagat person? Was he allotted? It was a question of cancelling. He was cancelled. Good. I hope you cut it. I did yes. The three repetitions are taken up for disposal by this common judgment and order. Okay, you take your seat. I'll do it. No. You made a mess of everything. Take your seat. In the year 2001, next, the facts involved in the instant repetition, in the three repetitions, relate to a project in the name and style of Jawaharlal Nehru National Urban Renewal Mission. Bracket ZNNURM, bracket closed. The said project was initiated taking into account the 2001 population census, wherein 285.35 million people were mentioned as residing in urban areas, which constituted 27.8% of the total population. As per the said population census, while the population in India increased 3 times, the urban population had grown 5 times. And the rising urban population had given rise to a number of urban poor. In the year 2021, as per the 2001 estimates, the slum population was estimated at 31.3 million. It is under such circumstances, the said project, that is Jawaharlal Nehru National Urban Renewal Mission, was initiated, which is called the Basic Service to Urban Poor, to cope up with the massive problems that had emerged as a result of rapid urban growth, for the purpose of providing basic service to the urban poor. The petitioners in all the three writ petitions were living in the GMC quarters situated at Potassic GMC New Horizon Colony. For the purpose of giving effect to the project, that is Jawaharlal Nehru National Urban Renewal Mission, the respondents in the writ petitions had asked the residents, including the petitioners, to vacate the earlier house/quarters situated at Horizon Colony with a view to providing them suitable and improved housing as per the mission. From the pleadings, it transpires that the Potasil GMC New Horizon Colony was divided into three zones, that is Zone A, Zone B, and Zone C. Mr. Dasgupta, your person was in Zone A, Zone B, Zone C? Nothing. The petitioners herein were asked by the respondents to vacate their quarters so that those quarters could be demolished, and thereupon new quarters which would be built on the basis of the mission would be allotted to the petitioners. Accordingly, as per the petitioners, they vacated the quarters and thereupon the said quarters were demolished. In WPC number 1822/2013, there are 30 writ petitioners. From the perusal of the materials on reports, it reveals that the petitioner numbers 1 to 24 were issued certain allotment letters of new quarters. However, as regards the petitioner numbers 25 to 30, they were issued a notice allotment, bracket, subject to verification, intimating that pursuant to their vacation of their quarters, they would be considered for allotment. In the case of the writ petitioner in WPC number 1265/2015, it is seen that the said petitioner was issued an allotment letter. In the case of the two petitioners in WPC number 3185/2019, it is seen that the same two petitioners were issued allotment letters. In the case of the writ petitioners number 1 to 9 of WPC number 1822/2013, as well as the petitioner in WPC number 1265/2015, the said petitioners are aggrieved by their cancellation of their allotments by the impugned order dated 21/9/2012. As regards the petitioner number 10 to 24 of WPC number 1822/2013, the said petitioners are aggrieved at the inaction on the part of the respondent authorities in not allotting the quarters to them and not handing over the possession of the quarters to them. In spite of a valid allotment. In respect to the petitioner number 25 to 30, it is the case of the said petitioners that they were in occupation of their respective quarters earlier, and they vacated the quarters on the assurance that they would be handed over new quarters, and thereupon no new quarters have been allotted to them till date. The grievance of the petitioner, of two petitioners in WPC number 3185/2019, is that the allotments have been duly made, but for reasons best known, the possession have not been handed over. From a records maintained, from a perusal of the reports, it is apparent that this court, by an order dated 5/4/2013, issued notice, and in the meanwhile directed restrained the respondents from making any further allotment of new housing units to persons other than the original allottees. The said interim order thereupon has been continued till date. Yes, what is your stand? It reveals that the respondents numbers 4, 5, 6, 7, and 8 have filed an affidavit in opposition. From the same affidavit in opposition, it reveals that out of the 352 beneficiaries, 83 beneficiaries have been left out. And possession has already been given to 269 beneficiaries. It was found on scrutiny. The list of 83 beneficiaries, out of the list of 83 beneficiaries, 11 names were found to be already dropped during the publication of the list due to objection from the general public and the Harijan Mazdoor Union. Out of the remaining 72 cases, what is this? 26 bracket, including five victim cases, have been considered for allotment after verification of documents and discussions with the BSVC. 2 cases are kept pending for further verifications. 23 cases are kept in the wait list for consideration of allotment after completion of the dwelling units in Zone C. Claims of 28 numbers of cases are cancelled by the House after discussion with the reasons shown against individual claims. During the course of the hearing, the learned counsel, Mr. S. Bora, appearing on behalf of the GMC, submits that taking into account that there are 33 writ petitioners in the instant proceedings, 33 flats have been kept aside and there has been no allotments made in respect to those 33 flats. He, however, submits that temporarily in those 33 flats, certain 5 victims have been asked to have been temporarily allocated. They have been temporarily not allotted. Have been temporarily allowed to reside. I think that is better. Temporarily allowed to reside, subject to subject to that they would vacate without any subject to the subject have been allowed to temporarily reside, and these families who are residing in the 33 flats have given undertakings that they would vacate. Subject to the outcome of the writ petitions, of the present writ petitions. Next. The case of the petitioners. The case of the petitioner number 1 to 9 of WPC number 1822/2013, as well as the writ petitioner in WPC number 1265/2015, is that The allotments which have been duly made in their favor have been cancelled without giving any opportunity of hearing to the said petitions. This very aspect of the matter have not been denied by the respondent James. Taking into account that the allotment orders which have been passed in favor of the petitions creates a right upon the petitioner numbers 1 to 9 in WPC number so and so, and the petitioner in so and so. And cancelling the said allotment ensures civil consequences. It is the opinion of this court that without giving an opportunity of hearing to the said petitioners would amounts to violation of the principles of natural justice and administrative fair play, and consequently would violate the mandate of Article 14 of the Constitution. Under such circumstances, this court therefore sets aside the order dated 21/9/2012 insofar as the allotments of the petitioner number 1 to 9 of WPC number so and so and the petitioner of WPC number so and so have been cancelled. As regards the petitioners, numbers 10 to 24, as well as the petitioners in WPC number 3185/2019, they have been allotted. They have been given allotment as far back as in the year 2010-11. This court made a specific query upon Mr. S. Bora, the learned counsel appearing on behalf of the GMC, as to why the said petitioners have not been given the possession. Why?
Number 1 and 2, 318.
And others? Huh?
All the reasons are given. There are also there is reasons are given. Page number 99 of this number. 182.
In waitlist, family members of so and so have been allotted.
Okay.
So they are in waitlist.
Waiting is there, and husbands are really some other.
Then why are you putting them in waitlist then? Why are you not cancelling the allotment?
They will consider later on they will verify, but waiting is for verification. Waiting is for even. They have already.
The learned counsel, standing counsel submitted that in respect to the petitioner numbers 10 to 24 of WPC number 1882, they have been put in the wait list for the reasons stated in the remarks of the order dated 21/9/2012. And this aspect would require certain verifications. The learned counsel, however, submits that in respect to the petitioners in WPC number 3185/2019, the said petitioners have not been handed over the possession in view of the pendency of the petitions. Huh?
Amount of factor
he further submits that the allotment fees also have been taken in respect to the petitioner in WPC number 3185/2019. Taking into account the above, now proceed. This court therefore proceed. The above answer to the query so made by the petitioner, by queries so made by this court, shows that the petitioners numbers 10 to 24 of WPC number so and so are not similarly situated with the petitioners in WPC number 3185/2019. As it has been submitted by Mr. S. Bora that the petitioner number 10 to 24 of WPC number so and so have been kept in the wait list as that for the purpose of making further verifications. It is the opinion of this court that the verifications cannot be allowed to remain cannot be permitted to continue endlessly, taking into account that the petitioners herein have vacated their earlier quarters and on the basis thereof the petitioners have been issued, the said petitioners have been issued allotment letters. Now coming to the question as regards the right of the petitioner, numbers 25 to 30. The said petitioners, though have not been issued any allotment letters, but they were being asked to vacate with an assurance that upon vacating their quarters, they would be issued allotment of flats. In the case of the petitioner that they had vacated their quarters, and thereupon they are therefore entitled to allotment. Would you have to say on them? Those who have not been allotted till now. No, they come in at Annexure 28 of the writ petition. They were asked that you vacate it, then you will be issued allotments. What happened? Huh? They did not? But they have vacated. Then, with your assurance, you will consider. This court further finds it relevant at this stage to take note of the stand of the respondents that those people, that the petitioners, numbers 25 to 30, if they have vacated pursuant to the notice enclosed as annexure 29, 28 to 32, they would be considered for allotment and subsequent and possession of the flats in which under such circumstances, this court therefore disposes of the instant petition with the following observations and directions. The impugn order dated 21/9/2012, by which the allotment of the petition number 1 to 9 of WPC number so and so, and the allotment order of the petitioner in WPC number 1265/2015 were cancelled, is hereby set aside on the ground of violation of the principles of natural justice. It is made clear that the cancelling, the setting aside of the order dated 21/9/2012 to the extent of cancellation of the allotment of the petition number 1 to 9 of WPC number so and so and petitioner of WPC number so and so shall not preclude the respondent authorities to take appropriate steps by issuing notice to the said petitioners and giving them an opportunity of hearing. Number 2. The petitioner numbers 10 to 24 of WPC number 1822 of 2013 cannot be made to wait for eternity in the wait list, taking into account that they have vacated their quarters in order to be allotted fresh flats as per the scheme. The responding authorities, therefore, are directed to take appropriate decision as regards the allotment of the petitioners, of the said petitions. And the same be completed within a period of how much? 3 months? Within a period of 3 months from today. The respondents said, it is further directed that the respondents that if the respondent takes any decision adversely to the petitioner numbers 10 to 24 of WPC number so and so, the said petitioners have to be heard, have to be issued notice and giving them an opportunity of hearing. Number 3. As regards the petitioner number 25 to 30, the said petitioners also have a right to be considered for allotment, taking into account that they had vacated the earlier quarters in pursuance to the allotment order bracket subject to verification bracket close, which have been enclosed as annexure 28 to annexure 32 of the petition. The responding authorities, therefore, are directed to consider their case within an outer limit of 3 months from the date of the instant order. It is made clear that if any decision is taken against the petitioners have to be given due notice and only after giving them a hearing. As regards the petitioner, number 4, as regards the petitioners in WPC number 3185/2019, as the same petitioners have already been deposited the amount, and the only reason why the possession had not been handed over is on account of the pendency of the instant petitions, which stands culminated with the passing of the instant judgment and order. The respondent authorities are directed to hand over the possession to the petitioners of WPC number 3185/2019 within 15 days. Oh, no. Within, at the earliest, within 30 days. Where is the problem now? At the earliest, and not later than 60 days. With the above, the instant petitions. Huh? I've already set aside. That is my first direction. Only as regards respond number 1 to 9 and cost upon the petitioner. Huh? For troubling all the councils, the judge, as well as everybody. Huh? Cost upon the council for the petitioner. This acquisition is made under the Assam State Acquisition of Zamindars Act of 1951. Why are you asking for 12%?
Law says that some interest is given. But since I'm not today. For provision, they should actually, I was not in the city. I was not in the city. So my dad, I was I had come, but they had a date of a wrong time.
Oh. Tomorrow, 2 o'clock. Madam, you get your instructions. Your basic case is that as the act does not perceive any interest, and as such, no interest has been paid. But the fact that there are various provisions of various judgments of the Supreme Court which says that even if the act does not, some form of interest if there is a delayed payment. We'll take it up at 2 tomorrow. Dispose it.
21 on 22.
Yeah.
My lord, I am the requisitionary. I cannot apply.
Then why are you here?
And I mean, respondent here. When it comes to-
Yeah. What is this matter about? Which one is the older one? 54 is whose?
Mine.
Okay. Yes. What is this case about? Such a big pile? Or what is this?
My lord, in the about the house was allotted. The existing numbers of allotted.
Ah,
It is 2014 one.
hmm.
And thereafter, my lord, some dispute raised that there is no anomaly in the list, and that was also corrected subsequently. And thereafter, some of the, in the weekend, my lord, resident of the government has been changed. And after coming to the new president, my lord, they have decided to not to implement the earlier list. So they are planning to give the houses to others. And as such, my lord, the petitioner approached this honorable court for implementation of the list of 23 numbers of allottees, my lord.
Hmm.
And this honorable court by the order dated lecture E, page 53. 11
12/8/2013.
page, my lord, 11 portion is page 63. 63, my lord. This rate petition was disposed of with a direction to the petitioner to approach to the government.
Hmm.
And the project director was directed to verify the list and to take appropriate action, my lord. My lord, page 64. Accordingly, this rate petition is disposed of with the direction to the petitioner to approach government of the council and the rural development department, indicating their grievances event. In the event of making such application by the petitioner, the grievance of the petitioner shall be verified by the project director DRDA Kamrup, said to be the competent authority, and thereafter the government passed appropriate orders there. However, entire exercise shall be completed by the authority as expeditiously as possible, because within a period of 1 month from the date of receipt of the application. While the disposing of the application's opportunity of hearing shall be given to the opposite parties involved. Accordingly, my lord, the petitioner submitted the order, certificate copy of the order along with the application that is 22 that is annexed G, page 65. And on the basis of that,
So you are challenging the order at Annexure J.
annexed payment.
So what is wrong?
My lord, kindly see the project director report, that is page 68.
Hmm.
Annexure I.
Hmm.
My lord, here relevant portion, my lord, page 69.
Hmm.
Paragraph, fourth paragraph on receipt.
Hmm.
On receipt of report from video Haju development block and after proper scrutinization.
Where Annexure?
Next page 69. Annexure I.
No, are you not challenging 18/12/2013?
That I have, 1812 I have challenged,
Ah.
but before that, my lord, this is project reports on, project, director's report, my lord, this is I am reading. Report was otherwise, but the order is passed otherwise, my lord.
Where is the report?
My lord,
Page
page 69 and
69.
60. Paragraph 4.
Ah.
On receipt of report from video Haju development block and after proper scrutinization and verification of the document records,
it is observed that out of 50 numbers of beneficiaries, 79 numbers of beneficiaries, petitioners having BPL ID numbers in permanent wait list are found genuine. 79 found genuine and eligible for allotment of IOY houses as per norms, except 4 beneficiaries, namely Anwar Hussain, Makibur Rahman, Alexan Ali, and Nelson Ali. Due to dissimilarities with family history of ID numbers at permanent wait list. However, in respect of Makibur, Rahman care of so-and-so measure, where it is found in his family history against the ID number so-and-so, that numbers of ID holders are reflected as R. Rahman Ali. ID number so-and-so BBS Ali. And the S such it resembles similarities with only three members except his son S. Ali. In view of the above, your good self is requested to issue necessary direction in the pursuance with order dated 12/8/13, passed in WPC number so-and-so, to incorporate the names of IAY beneficiaries from the permanent list, wait list as per score and ID numbers in respect of 3 or 4 numbers of beneficiaries which are found to be erroneous, or may direct to hold a fresh Gram Sabha meeting to select 3 or 4 numbers of beneficiaries and the other lines. So, my lord, out of 83 beneficiaries, my lord, 79 found genuine, and it is in the report, my lord, it is suggested that only 3-4 numbers of beneficiaries should be special meeting should be held by for selection of 3-4 numbers beneficiaries. But my lord, pursuant to that report, my lord, the principal secretary, additional chief secretary, government of Assam has passed the interim order, my lord, whereby directed that 83 numbers of candidates should be selected afresh. That's why, my lord, this repetition has been filed.
But your project director, upon whom you lay so much of hope and aspiration, he has filed an affidavit against you. He has filed an affidavit against you.
My lord, that affidavit, my lord, can we say,
I've seen it.
my lord, in resolution, my lord, page 27 in the affidavit. My lord, in the meantime, my lord, in this repetition, there is an interim order. 1/6/2045. Interim order, my lord.
No, what is your right? Tell me. So many affidavits. No, what is your right being selected in the Gram Panchayat which was not held properly?
My lord, it is as per project director's report. Out of 83 numbers.
The project director says out of 83, 79 were okay. So go with that flow.
73 numbers should be allotted.
Why? They want to hold it properly, then let him do it. What is your problem?
Well, this is against the order of this honorable court.
This order of this honorable court has nothing said that it is a disputed question of fact, and as such, we are not going to decide anything. You were directed to approach the authorities, and the authorities have decided. Pursuant to these reports and all have come to a finding that those which was held, the Gram Sabha was held on 2 dates, that is on 21st and 23rd, and it was not done properly. There were a lot of loopholes, and as such, we direct that a special Gram Sabha will decide it. It's a simple matter which is pending for the last 10 years.
The competent authority is the project director to verify the list. And the project director, after verification, submitted the report.
Understood.
The landed, my lord, one of the additional chief secretary, my lord, has to give an emphasis on the report, my lord.
He has not only the report, he has also heard the project director.
My lord, that order, my lord, that order.
Are you saying that the project director was not heard by the additional chief secretary? Are you saying that the project director was not heard by the additional chief secretary?
My lord,
Because the project director files an affidavit which goes absolutely against you.
but this honorable court has passed an interim order pursuant to, my lord, this writ petition that, I am reading the interim order, my lord. And then the subsequently they have violated the, this honorable court order.
Where? In some miscase,
My lord, I have annexed that.
no, in some miscase.
In the subsequent, item number 22, my.
No, you are saying about the order of 6/1/2014.
Another order is there are two orders. One is interim order 6/1/2014. Passed it in this petition, my lord. 54 of 2004.
Yes.
And this order is, my lord, relevant, my lord, this, I have filed an affidavit in opposition in item number 20.
Okay.
In that affidavit, my lord, I have annexed this order.
Then,
And pursuant to that, my lord, it is clearly stated, my lord, order on the council for the parties on the interim prayer. Considering the earlier order of this court, 12/8/2013, passed in WBC number 2091 of 2013, and the report of the project director dated 25/10/2013. It is hereby provided that special Gram Sabha meeting as has been proposed by order dated 18/12/2013 shall not be held in respect of 79 petitions.
where are you getting the word shall? Where is the word
My lord,
shall?
May not be.
Ah,
held-
may not,
May not be held in respect of 79.
may not. May not. It is not shall.
So 79 petitioners, my lord. Now, my lord, my humble submission before your worship will get. And already, my lord,
Yes, Mr. Bobby, what is your case?
My case is, my lord, whatever my learned friend is projecting, my lord, that is not the case. Because, my lord,
You want the special Gram Sabha.
my lord, I want a fresh, my lord, that.
And you have,
And
and
then both the parties, my lord, all
Huh?
the dispute will be over. Once for all, my lord.
yes,
a fresh Gram
let
Sabha
them
will be
decide,
there,
or
my
should
lord.
this board decide all
Because,
this
my
thing?
lord, we obtained outgoing precedent, my lord. On the last day of going there, taking 10,000 per head, my lord, for which we have registered FIR against the outgoing precedent. That is the dispute I have annexed all the. So had it been like this, my lord, keeping aside all these things, my lord, let it be a fresh council. Then, my lord, appropriate authority. will-
And how many petitioners are alive? Petitioners are alive to take the houses.
all the information.
Huh?
Have not information that now.
They want to hold a press gun. What is your right? Tell me. To get an allotment?
My lord, newly applied.
No, show me. No, but Mr. Dey, kindly show me what is your right. What is your right on the basis of a resolution taken by the Gram Sabha?
My lord,
Do you get it just on the basis of the resolution of the Gram Sabha?
It is the newly elected president who wanted to, my lord, this list was prepared before the new president is elected, my lord. After coming, just after coming.
I
she
understand
wanted
everything.
to- she wanted
No,
to-
it is all the president who has made the difference.
My lord,
Yes. Now, tell me what is your right on the basis of being there in the list of beneficiaries?
my lord, what is the illegality of that issue? Select list.
So what is the problem? When the authority wants to hold a special Gram Sabha, what is the problem?
In pursuant to the newly president and secretary.
Now the president and secretary may not be there.
They are not.
Then what is your problem now?
My lord, even they go to the extent that by resolution, newly president has taken a resolution that is in their affidavit.
Understood, that president is no longer there.
No,
Is he there?
no.
Oh, then Your fear out of that precedent is over.
Has been cancelled by the.
My lord, it is a big conspiracy to cancel the earlier list by this.
Understood. What is your right on that list?
My lord. So far,
So far, so good. I think it needs to be done. What? Withdraw?
Well, then, my lord, the scheme is not no more.
Huh?
IY scheme is no more now.
See?
2016, my lord, that PMY, Awas Yojana, yes, my lord, coming to force.
So IAY gone. And both of you are fighting. See?
name is but
Name may be changed.
they are exactly for-
What has happened now? Have you given it to these people? Some other people have been chosen for this.
No.
Whether these houses were built,
No,
houses not built.
no,
My
only
goodness.
the allotment is given. That was my lord.
And the allotment can't
Not
be given.
my lord.
Allotment, huh?
No allotment, but the.
It was a recommendation.
Only select.
It was a recommendation, which is to be approved by some people from the DRD. No, not DRD, PNRD.
Ram Sabha has to be elected by the selected number of.
No, it is only a select list and that has to be approved by the authority. So that select list is gone. What is there? And by the time both of you are fighting, scheme is gone.
What I'm getting, fair solution, my lord, let them be a press council from my lord. He is entitled, he get, if I'm entitled, I'll get whoever entitled.
So what to do now? No, it is a question of withdrawal.
My lord, the name might have been changed, my lord, for benefits, sir.
Withdrawal of the writ petition and approaching those authorities. That is the only thing. Because otherwise, this court is going to dismiss it. In dismissing this, the court is going to hold that you have no enforceable right. The moment I hold it, which goes against you, let us, if they hold it. Now he says there is no IAY. DRDA has gone. The person on whose basis you were there, that is no longer in existence. There is no project director nowadays. Then what is left? I would have understood, like in the earlier case, there is some quarters made. Here, it is only a thought process. Infructuous.
Can it be like this, my lord?
Yes.
After close the petition, my lord, giving liberty to estate before the appropriate officer. In case we are entitled, we report it. That will serve purpose of my learned brother also, as well as government also, as well as myself.
Now, the instant repetitions. What is your prayer?
My prayer is, my lord, I'm challenging two orders where they said, my lord, my selection list was null and void by virtue of their content list. That I,
No. Well, here you are challenging what?
I'm challenging. my
You are also have a standing of 80 people. He also has 80 people.
No, my lord, he is 79, I am 80.
You are 81.
83.
No. Mustafa Ali and 80 others. And what about the Kofi? Kofi, you paid?
On that time, it was not.
Huh? My goodness.
Second, my lord, I challenge my lord, please, 100. No, my lord. That cannot be a binding upon the authority, my lord, while setting it down. That will-
100?
That your lordship will see as change.
What?
102.
102.
200. Portion number
6/2/2014. There was a Gram Sabha held on 6/2/2014, on that very date on which the interim order was passed.
No,
When was the interim order passed?
6/1/14.
Okay, so without holding it, the Gram Sabha was passed.
Fine.
And for that, he has made violation.
Fine, yes.
That is it. And you are challenging this
I'm challenging this.
because this was said that kindly cancel the Gram Sabha.
Then also will see page 103, my last paragraph. 103.
Ah,
Direction from the government to be issued the project director Kamrup in under section 20, also not to give effect to the posting of the Gao Sabha to the extent violates the order of the honorable high.
So these also had nothing, no relevance.
No relevance. Then, my lord, 104, that is one. Selling price.
This, because this repetition has happened on account of an interim order passed whereby some Gram Sabha was held and on the basis of which you were selected. And that was not to be given effect to as per the directions of this court.
No, direction was that, my lord, that meeting shall not comprise of the 79% belonging. Page 86 is the order.
I've read that order,
Then, that's all you about that.
6/1/2014.
Yes,
Says what? It is hereby provided that a special Gram Sabha as has been proposed by order dated so and so may not be held in respect of 79 petitioners.
that will be.
Yes. So meaning thereby that Gram Sabha which was held earlier, for which you are, and as the project director's report was, that 79 petitioners were okay. And as such, don't hold the special Gram Sabha for these people. You may hold for the remaining 4. That is what was the direction. So then what is wrong by these orders?
No, that is the implied.
Yeah.
While my
Therefore, the instant repetition, both the repetitions are taken up for disposal by this common order. 79 writ petitioners have filed WPC number 54/2014, challenging the order dated 18/12/2013, passed by the additional chief secretary to the government of Assam Panchayat and Rural Development Department, whereby it was observed that a special Gram Sabha meeting would be held for selection of 83 numbers of Indira Awas Yojana beneficiaries, IAY beneficiary, pertaining to Saniadi GP under Hazau Development Block, in presence of the representatives of the Deputy Commissioner and Project Director, DRDA, Kamrup, BDO, Hazau Development Block, and other concerned officials, so that only genuine IAY beneficiaries are selected for the Government of India flagship program, strictly as per the relevant guidelines and instructions issued from time to time to meet the ends of justice. It is the case of the writ petitioners in WPC number 54/2014 that the said order dated 18/12/2013 is perverse in as much as the report of the project director, District Rural Development Agency, Kamrup, dated 25/10/2013, was not taken into consideration. It is the case of the petitioners in the said writ petition that the project director had given a report to the extent, to the effect that out of the 83 beneficiaries who were selected, 79 beneficiaries were in order, whereas the 4 beneficiaries were found not genuine and eligible. It is under such circumstances the instant writ petition was filed, and this court, by an order dated 6/1/2014, directed that the special Gram Sabha meeting, as have been proposed by the order dated 18/12/2013, may not be held in respect of 79 petitioners. Subsequent to the said order dated 6/1/2014, a special Gram Sabha was held. The petitioners in WPC number 54/2014 initiated contempt proceedings. Pursuant thereto, the project director DRDA, Kamrup, issued a communication to the commissioner, PNRD, requesting to issue appropriate orders declaring that the proceedings of the Gram Sabha held on 6/2/2014 as null and void, taking into account that the said Gram Sabha was held in violation to the orders passed by this court on 6/1/2014. Further to that, by another order dated 6/21/8/2014, the Commissioner, Panchayat and Rural Development, Assam, had written to the Principal Secretary to the Government of Assam, PNRD, stating inter alia that the proceedings of the Gram Sabha, to the extent that it violates the order of this court dated 6/1/2014, should not be given effect to. These two communications, that is the communication dated 19/8/2014 issued by the project director DRDA, as well as the communication dated 21/8/2014 by the Commissioner, Panchayat and Rural Development, Assam, have been put to challenge in WPC number 122/2015. By the petitioners, by 81 petitioners who claims to have been in the select list as per the newly held and as per the special Gram Sabha held pursuant to the order 13. The learned counsel appearing on behalf of the, you are appearing for whom? Huh? No, whom? Otherwise, submits that the said order dated 18/12/2013 have already lost its force, taking into account that the scheme for allotment of houses to IAY beneficiaries have already been abolished, and the same have now been
Pradhan Awas PM,
PMGY.
PMY.
Why? And the same have been now
Pradhan Awas.
replaced by the Pradhan Mantri Awas Yojana, AY. He further submits that as per the new scheme, that is Pradhan Mantri Awas Yojana, the manner of selection of the beneficiaries is not the same as was in the case of IAY beneficiaries. And as such, the order which have been challenged in WPC number 54/2014, that is dated 18/12/2013, have already lost its force. Further to that, the Learned Council submitted that even the list prepared in the special Gram Sabha meeting held on 6/2/2014 was under the IAY scheme. And as such, the same had also become redundant, taking into account that the IAY scheme is no longer in existence.
Amount was given 70,000. Now it was given 1,00,000.
And apart from that, the manner in which is different.
And then 12,000 is given for some types of the project.
Taking into account the above, as the IAY scheme has already is replaced by the PMAY scheme, and the manner of selection of the beneficiaries is different, and as well as also the entitlement is different. It is the opinion of this court, nothing survives to be decided in respect to the order, impugned order dated 18/12/2013, as well as also the validity of the select list of the beneficiaries in the special Gram Sabha held on 6/2/2014. As the same have all, or as the same had already become redundant. Considering the above, this court therefore disposes of the instant petition, holding that the impugned orders challenged in the petitions have already become redundant, and thereby granting the liberty to the petitioners to approach the appropriate authorities for redressal of their grievances in respect to the extent scheme for grant of benefits. Yes, Mr. Mishra. What is it? You are waiting till 4:30? What is that item?
Regarding a short matter. For this.
Let's see. Yes, others will go. Item? Okay, 911. What is that matter about? Oh, okay, okay. Yes, Mr. Bogotudi? Yes. When do you want it? 911. 911, too many matters out there. It's just opening. We'll have it on 1611. Yes, Mr. Mr.
I just, taking it comes to the point that is in,
Yes,
can we have this, master plan during review? That it is,
yes.
can we come to 284? Page 280.
Yes.
Chapter is pathway, proposed land use plan.
Mhm.
So this is the next page. That is basic consideration.
Basic consideration.
Basic. I will skip that. And I'll give you options to 296.
296, yes.
Come to 288. 288, planning unit, 10.4.
Hmm.
Paragraph 10.4. You option to come to the right side, 289, and serial number 5.
Depot bill.
Before we further I want you to go to. This is your what you kindly keep in mind, it's serial number 5. Now kindly go to 297.
Mhm.
297.
Yes.
297 is just below the burial ground, below 2. This position of industrial area immediately intersected with commercial area, offices and residential area in terms of the travel time. All these centers happen to be major traffic generating modes of city. These centers therefore require special treatment by way of location, position of service and accessibility. Proposals regarding linkage and accessibility have been described with traffic and transport. It is true, the development of the industries in Guwahati have ample scope, but no non-availability of stable labor in Guwahati master plan area seems to be acting as hindrance. However, considering the above fact, plans are reserved for accommodating industrial growth in planning unit site in consumption planning area. This was their mark for industrial area and industrial area, and I have set up my plan there. It's a medium area. Now, if I come to the 2025 master plan. It takes you to part two. That's it.
Yes. Part one.
Part.
Yes.
Kindly come to page 3. It is at the bottom of the right side.
Hmm.
13.2.
Yes.
The land proposed to Guwahati metropolitan area has been categorized into 9 categories. You are 9. And it is composed of zone 2, including residential, commercial, and existing industry. So my industry is safe there, but the user has been changed. It is now residential and commercial.
You were earlier
Industry.
medium industries. As per this,
As per 86.
86, you were medium industry.
Now the land use has been changed. Although the existing industries have been protected. My apprehension is that number one, I cannot expand. I cannot expand my industry. Number two, because of the time as the time passes, there will be residential areas. Then there will be complete of pollution because emission of pollution for industrial area and residential area. Now, what we are agreeing is the Guwahati metropolitan GMDA is entered. And earlier, 1986 is under the Assam Town and Country Plan. So there, the government has the authority over the entire state. Under section 10 and 10, they have made this, the 86 plan. You could logic can have some 92 notification. 92 notification is at page, the 72 of the report. This is in under the DMD Act. This is actually dated 23/3/1992, but it's not clear. We have got the copy.
You're referring to page 72?
72 and action E, that's
Yeah.
in exercise of power conferred by the same law. In exercise of power conferred by section 1 of section 3 of Guwahati Metropolitan Development Authority 1985. The governor of Assam is hereby pleased to declare Greater Guwahati Master Plan Area as described below shall be the Guwahati Metropolitan. And this has been taken in fact verbatim from 1986. From 1986.
From the date when this GMDA
Not
came in.
under the power.
No, when the date GMDA came in 86.
Here, GMDA came in 1985, so statutory body came under GMDA Act 1985.
But it was brought into effect on 86.
87.
4 to 86.
Now, the act has come on 10/11/1987. It was published in the and it came into force on 1/4/1990. The third page, is of course 19.
Page 195.
No, what I read from the second page.
Okay.
Usually we made it from the notice for publication of the modified master plan and new regulation for bonds. It is notified that modified final master plan and new regulation for Guwahati where the director of town or country planning commission and adopted as a state under section 10(2) of the Assam Town and Country Planning Act 1969, where the speaking of Assam Town and Country Planning Act for the area described in Schedule 1. The option to see the area which is described, if the option to find it verbatim. It includes equation of area. District Council subdivision Guwahati, approximate area going to. Then revenue areas are included in the modified final plan from after Guwahati Municipal Corporation, norm, Guwahati Town Committee and other revenue area committee. And 92 is verbatim reproduction of this.
Yes. Yes.
A question that I asked by whether subsection 1 of section 3 of the Guwahati Municipal Act 1979 empowers the government to issue this notification by which the Guwahati Metropolitan Development Authority has been given the jurisdiction within these areas, that is both Greater Guwahati Master Plan. That is the question if the Lordship will kindly from 71 Act. 71 SPS 240.
You're referring to section
Section 3.
of the 85.
Sorry, not 55. Sorry.
Declaration of
That
Guwahati.
is the same. Subsection 1 of section 3. Declaration of Guwahati Metropolitan Area. The state government may by notification the official gazette declare the area covered by Guwahati Municipal Corporation area and any other area contiguous to the Guwahati Municipal Corporation area to the Guwahati Metropolitan Area for the purpose. Therefore, what area allot can be declared as an area within which the PMDA will exercise jurisdiction is the area covered by the PMC Act 1971 or contiguous. They cannot go beyond this. But if the Lordship has a look at this, they are going beyond. They are crossing my Lord North, Guwahati Town Committee, other revenue areas mentioned below. So the Act does not empower. So this is the question which has popped up. Okay. Very good.
The GMC area is where?
PMC area manager, your option to see section 1 of 71 Act in the same book, 1971, section 1. I'll place first subsection 2 of section 1. Except as hereinafter otherwise expressly provided, it extends to the city of Guwahati. Now, city of Guwahati has been defined under subsection 9 of section 3. Page number. City of Guwahati or city means. Would you this?
Yes. Section?
Subsection 9 of section 3.
Section 9 of,
Section 3, subsection 9.
oh, section 3.
Page 4.
Okay.
City of Guwahati or city means the area within the boundary to be specified by the state government in this behalf and duly notified official gazette in the official gazette from time to time as required and 42.
Now, the lordship will come to 42 at page 25. Declaration of local area and city of Royal Guwahati for the purpose of this act, the area within the limit to be specified by the state government in this year and duly notified in the official gazette and constitution the city of Guwahati. Government may from time to time after consultation with the corporation by a notification in the official gazette alters the limit so as to include therein and exclude there to author the area and specified. So these are there, and then 43 is delimitation of. So what we have done, since we have not found any map showing the area which is under the Guwahati Municipal Corporation. Under 43,
So there is no notification.
we did not play our hand.
Huh, Mr. You have a notification?
So can I see page 8 of my agenda?
Page 8.
Yes.
Yes.
31st of March 2007.
Page 8.
Election.
Notification. No. Page 8 is GMDA.
Yes.
Now, what about the GMC? You don't have a notification in terms with that provision of section 42?
This is in terms of section 3 of the-
Of?
This is an estimated further distance.
This is of 20 of the GMDA. No, we are concerned with the GMC because his submission is that as per section 3 of the GMDA Act, you can have the GMC area and the contiguous areas and not beyond that.
For that, your lordship will have to note that this authority lies with the CFC, we cannot be
Which one?
this drawing of the master plan.
That is with the GMC.
So for today, lordship only is with finish of 2014 law. And just now I'm doing the five law, and I have
Okay.
one benefit of the department, GMP authority is also here.
Ah.
I will have to definitely, I will have to go to the site. So for a product that comes to my notice. Like GMDA claims, this is, they have the authority under the GMDA Act of 1995, as per section 2. That is clear.
No, they have the authority, but the GMDA has been constituted, area has to be constituted by under section 3. If it is under section 3, you can have the GMC area and the adjoining areas, or the contiguous areas, meaning thereby it cannot go, you can't have a gap in between. Because if you see, the places like Dharapur, which is the subject matter here, whatever may be, Dharapur and all, Mirza, Azara and all, they are not contiguous. Can that be done? That is what his submission is.
Even Tarapur and those areas
Therefore, you have the Gaon Panchayats there.
are here from 2009 lordship, it's under GMDA, under the master plan.
No. GMDA, there is no quarrel. I'm not asking about the GMDA, but the power that you can get only if it is GMC and adjoining contiguous. You can't have in between something else. Because in Azara and all, if I'm not wrong, the GMC does not extend. Does it?
GMC not prohibited. GMDA is existence.
The GMDA is because of this notification which he has brought in. And that notification of 1992, it categorically says that yes, therefore you have these villages. It comes on all under the Palaspoli revenue circle. This Borjar, Kahikusi, Jugibad, Dharapur, Goralgaon, Mirza, Azaragaon, Mikirpara. These are all outside GMC area. These Dharapur and all, they come on outside the GMC area.
But I also, yesterday only I saw it after many years. That again,
What is being included is the GMC Municipal Corporation, not Guwahati town committees.
Panchayat area.
Huh?
Not Panchayat area.
And other revenue areas. No, these are panchayats too. These Dharapur and all these things are panchayat areas. Therefore, you have a lot of litigations out there as regards the permissions granted by the panchayat in those areas mostly. Sure. We'll do one thing, Mr. Mishra. Yes, when can you be ready?
Our objective is already there. The meantime, I will.
Sure.
But otherwise also you not notice. This is merely on the list of applications. That in future, you may not be able to extend it. Nothing else, not be. I think the only way to and legal question is now. Very good. Because I can inform one thing, after this report file, this second time. Earlier there is an order. The departments are after report file, the industry was against it. And he also. The industry was there, and the posted community concept. But the key. So that's one.
So we will have it on 12th.
Well.
17th is too close to the holidays. I have no problem. Every day is a hearing day for me.
Well, yes, you think it's subject to some.
Yes. Is the matter again on 12th to further consideration. Thank you.